it please the court, this is SU 15CR254, State of Georgia versus Kiari Kendrell Cephas. Mr. Cephas is before the court, represented by his attorneys, Mr. Lovett and Ms. Goldberg.
That's correct. Yeah.
Okay. And it's my understanding he wishes to change a formally entered not guilty plea to a plea of guilty to count one of this particular indictment. It's also my understanding we have a joint stipulation between Mr. Cephas and his attorney and the state that if required, the state could prove beyond reasonable doubt each and every material element if required to present it to a jury or a court, and that also it would be in his best interest as he is offering this plea under offer. He would enter into a stipulation with the state and his attorneys that it would be in his best interest to plead to the factual basis that while being in Bullitt County Jail, legally confined at the penal institution of Bullitt County, did unlawfully commit an unlawful act of violence by of battery on inmate Brady Collins Weathers, contrary to the law of the state. He is also charged with the lesser included of battery on this particular case. We're going under the concept of merging the two, ask that count two be null prost, and he'd be allowed to make his plea to the count one. We do have a joint recommendation to offer to the court in return for this change of plea, and it would be, as to count one, 5 years, which would be probated. He would have to pay a base fine of $1,000 plus all surcharges and applicable drug surcharges and drug conditions. As a condition of this probation, he would be banished from the Ogeechee Judicial Circuit. And also, we would ask that he would receive credit for all the time that he has served in this particular case. And we would actually like it to go all the way back to the day of his arrest, which would be 4/19/2015, is my recollection. Correct me if I'm wrong on that.
That's correct.
That would be our joint recommendation as to this particular case.
All right.
He's entering it under offer. Furthermore, we have discussed the case about what's going to happen to it as we go along. And we want to put on the record that we have discussed the potential to reevaluate the case after some time has passed in the event of some request for early termination. Simply, we're just representing the court that we're not going to close the door on that, and we'll be happy to review his criminal history at that point or any other issues with probation and see where he is as he goes along on this particular probation where he's in his plea.
Fine.
We would further announce that we are in the process under SU 15CR285 in resolving that and the multiple co-defendants. Based on our discussions as they stand right now, if the parties come before the court as a part of this indictment and take responsibility for the various contraband which was seized in this case, it would be our intention at the conclusion of those pleas to file a written null pros request to the court as to
Mr. Cephas.
I'm sorry?
As to him?
As to Mr. Cephas on 285.
All right.
And that would be our joint recommendation.
Your Honor, let me say something for the record on a couple of those items. Number one is I agree with everything said under the riot in a penal institution charge. My understanding is at the conclusion of 2 years, Mr. Black would take another look at the possible early termination of the case based on Mr. Cephas not having been charged again in other charges, in some other jurisdiction or this jurisdiction. Any recommendation by the probation officer or a change in status, such as non-reporting by Mr. Cephas at that point, Mr. Black has said he would make a possible reevaluation, possible termination at that time. My understanding on the drug case, which is 285T, my understanding was that case would be, as to Mr. Cephas, that would be null pros. That's my understanding.
That's what I just heard.
So, as far as we're concerned, this is it for Mr. Cephas.
That's what I just heard.
Okay, all right. Thank you.
Now, let me say this. Mr. Cephas, as far as I'm concerned, will be treated as any other probationer. After 2 years, typically, the non-reporting is standard.
Yes, sir.
And I certainly would have no problem, although I would not hopefully be on the bench at that time in 2 years if probation is recommended to be terminated if he has no other criminal activity. I don't see any big problem with that, and I will put on the record that it is the court's intention that at that time, should he behave himself and not have any other charges and have done all the things that he's supposed to do on probation, the court certainly would not have any problem with an early termination.
Thank you, Your Honor.
Does that make some sense?
It does, Your Honor.
Mr. Cephas, would you raise your right hand for me?
Yes, sir.
The evidence you'll give is sworn or affirmed to be the truth, so help you God.
Yes, sir.
You can put your hand down. Your name is Kerry Kendrell Cephas, is that right?
Yes, sir.
Now, with your permission, I'm going to write your name on here because it doesn't appear, all right?
Yes, sir.
You can see I have written your name, and that's the only change I've made to it, correct?
Yes, sir.
How old are you, Mr. Cephas?
23.
How far in school have you gone?
Graduate.
Good. You don't have any trouble reading or writing.
No, sir.
That would ordinarily be none of my business, but I have in my hand a sworn statement. It appears to have your signature on the back. Did you sign that?
Yes, sir.
Did you and your lawyers go over these questions?
Yes, sir.
There are 18 in number. Yes appears as an answer beside each of them. Did you answer yes to all of them?
Yes, sir.
Do you feel as though you understood the questions?
Yes, sir.
Okay. You understand that, as charged, you could go to jail for 5 years.
Yes, sir.
You understand you have a right to a jury trial. You'd be presumed innocent of the charges. The state has a burden of proving your guilt beyond a reasonable doubt.
Yes, sir.
You have a right to cross-examine the witnesses for the state. You have a right to compel witnesses to come in and testify. You have a right to testify, but you're not compellable to testify. That just simply means you can't be forced to say anything about anything. You understand?
Yes, sir.
The burden is always on the state to prove your guilt. You understand that?
Yes, sir.
And you have a right to have your lawyer with you at all phases of the trial, who would help make arguments to the court or jury, and would help present any relevant evidence in the case. Now, you're giving up those rights by offering this plea to me today. You understand that?
Yes, sir.
You have heard the recommendation that's been made to me. Was that your understanding of what the recommendation would be?
Yes, sir.
Okay. Now, I am asked to accept this under the authority of Alford versus North Carolina. Don't be confused. Alford is a guilty plea, but it's also called a best interest plea. In regard to that, I'm going to ask you a couple of questions, okay?
Yes, sir.
You're charged with riot in a penal institution, and as Mr. Black said, a lesser offense of battery. Specifically, you are charged on or about the 2nd of May of 2015 while being legally confined in the Bullock County Jail, a penal institution of Bullock County, a political subdivision of the state of Georgia, did unlawfully commit an unlawful act of violence. By committing an act of violence and battery on inmate Bradley Collins Weathers, contrary to the laws of the state of Georgia. Now, you've had ample opportunity to talk to your lawyers about the advisability of taking this to trial or the advisability of entering a plea of some kind, which you are here to do today. Is that right?
Yes, sir.
Having taken their advice into account, knowing your version of the facts of the case, knowing something of the state's case with regard to how it would be presented from their standpoint, is it your considered opinion, not your lawyers, but your considered opinion, that it is in your best interest to enter a plea under the authority of Alford versus North Carolina to this offense?
Yes, sir.
Are you satisfied with the services of your lawyer?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Anybody threaten you in any way, promise you anything to make you plead guilty?
No, sir.
Are you today a United States citizen?
Yes, sir.
There is something in the law called the petition for writ of habeas corpus. That is a legal way, a fancy way of saying that you think there are irregularities in the prosecution of the indictment, and you want a court to take a look at it. If you wish to file an application for such a writ, you must do so within 4 years plus a 30-day grace period. Do you understand that?
Yes, sir.
I believe Mr. Cephas understands the situation with regard to the charges. I accept the plea as being freely and voluntarily made. Further, I have questioned him concerning the specific allegations. I accept the plea under the authority of Alford versus North Carolina as a best interest. I believe that he has thoroughly thought this out and believes that it is in his best interest that he enters such a plea. Please accept it and the recommendation. It'll be a 5-year sentence, which will be probated, $1,000 base fine plus surcharges. You're banished from the Ogeechee Circuit. That's Bullock, Effingham, Scriven, and Jenkins counties. Credit back to 4/19 of 15, as I usually do. Waive the supervisory fee until the fine is paid.
Thank you.
Special conditions will apply, including the banishment. There's also a special condition which the probation office will go over with you. It's number 10. It's a Fourth Amendment waiver. Law enforcement will not have to get a search warrant to search you or your property during the time that you're on probation. Do you understand that?
Yes, sir.
All right. Do you have any questions about your sentence?
No, sir.
Do you feel as though you understand it?
Yes, sir.
Is there anything I've omitted?
Your Honor, the only other thing, if we did put the release date would be today, credit for time served, and also.
He has pled, he is to be released.
Yes, sir, he'll be discharged from any other
He,
crimes known by the state.
well, assuming everything goes forward with the rest of it, I guess that's the case. Now, he will have to meet with probation, but you all can set that up. And I don't know when they'll meet with you, since it's this afternoon. Ms. Simmons, you got a time to meet with him?
Yes, sir. If we can request that he be held in county jail for at least another hour, and we can go over there and process his paperwork.
That work for you?
Yes, Your Honor.
All right. Go talk to him at the jail, and then he can be released as soon as they can process him, all right?
Thank you.
Good luck to you. All right, we got anything else we can do?
Thank you,
If
Your
I
Honor.
could, I'll go quick